My name's Pauline Tesler, and I'm a certified family law specialist practicing in California, primarily Mill Valley and San Francisco. And I came to law school as a second career during the 70s when there was a lot of political activism going on, and I wanted to be a public interest and legal services law reform lawyer more than anything. So I went to the University of Wisconsin Law School at Madison, which was a great place for me to be. I had been living and working in Chicago, and I went up to Madison for my law work. And that was a law school that integrated law and social policy. That's pretty common now, but it wasn't so common then. And I came out of law school, came to California, and did go into a legal services backup center doing children's rights work. And from there into family law. When the Republicans got elected, way back then, Reagan got elected, money disappeared for legal services, and I became a private practitioner and started doing family law. And in the mid-90s, I shifted to collaborative practice, and in the late 90s, restricted my practice just to collaborative work and second opinions and consultations, and was invited to present a talk at a conference given by the Judith Wallerstein Center for the Family in Transition. It was a wonderful conference on new ways of working with families in transition, and I had never given a talk before of this nature, certainly not to an audience like that. It was an interdisciplinary audience, very sophisticated thinkers in our field, and so I really worked hard to pull together all of the pieces of why I thought this work was so important and how I was going to integrate psychology and what I could see about social policy and what I could see about demographics and all of the different pieces that seemed to me to come together in collaborative work. And I remember in my conference room, I unrolled a long sheet of butcher paper around the walls of the conference room, and I took Post-it notes, and I created an outline that just kept getting bigger and bigger, and every time I read something, I'd stick another piece on it. And the talk that I gave, I was really pleased with, and it became the foundation for being invited to do a lot of other things that led me to where I am now. But one of the things that it led me to was that I decided to write it up as an article, which then, you know how these things work, is that I then I was invited to give presentations at AFCC conferences. And at one of those AFCC conferences, Barbara Stark, a wonderful collaborative lawyer and financial consultant from New Haven, she was on the publications board of the American Bar Association, and she said, this really needs to be a book. It never crossed my mind to write a book, but she encouraged me to do it. And the thing that convinced me was that she said that they were the most forgiving publisher anywhere. If I was late for deadlines, that'd be okay. So that gave me permission, and so I wrote the book that people refer to sometimes as the Blue Book, which was called Collaborative Law, and it was the first serious book on the subject, and I had a great time writing it. It wrote itself. It was just one of those periods of creative ferment. I took a couple of weeks up in the mountains, just myself and my computer, and I'd go for a walk, and a chapter would take shape, and then I'd come back and I just would type as fast as I could into the keyboard it in, and then the next day there'd be more, and it just wrote itself. And that one is now, I'm really glad to say that I've got a second edition of it, which ABA just published in August of 2008, and I wrote the first edition in 2000, 2001, and the field has moved so fast that a really expanded and revised second edition was necessary by 2007. I just had to rewrite it. So the book came out in 2001, I think. And at the same time, I had written an article for the American Psychological Association. They have a journal on law, psychology, and social policy. So I was starting to write. I had never really done that before. And it just caused one thing to lead to another, and I started doing trainings right about that same time. I think the earliest trainings that I did were in Texas with Stu Webb. They were sponsored by John McShane, who's a force in and of himself. He was determined that Texas was going to become a collaborative practice state in 12 months, and he had a strategic plan for it. And by God, it happened that way. So I liked doing training. I loved doing training, and I've just continued on that pathway. Somewhere in the midst of this, Peggy Thompson and Nancy Ross were working on a parallel path right across the bay, 20 miles from where my office is. And eventually, Peggy and I discovered each other. Peggy was creating a team model, and she had been exploring something I've talked about today. From the client's perspective, if you identify certain needs for interdisciplinary services, what's the best configuration to deliver them? And she and Nancy had been experimenting with every way they could think of, and they had come up with this 2 coaches, financial consultant, 2 lawyers, but they hadn't known about collaborative law. And of course, the lawyers were the lead weight that were sinking the process every single time. And then when she discovered that there were actually lawyers working in a way that was congruent with what they were talking about, that really was the big light bulb going off for her. It took some time for the lawyers to be as persuaded that what she was doing was exactly what we needed. But inexorably, that's been the direction in every single community, even communities that said very forcefully in the mid to late 90s, that may be okay for California, but we'll never do it around here. I heard certain Texans say that, who now are leaders in the interdisciplinary team approach. Peggy and I formed a group with some other people in the Bay Area that was a lunch group over across the bay in Emeryville. There were maybe 10 or 12 of us. Jenny Jackson was in it, Nancy Ross, some other people. And at that group, Peggy was the visionary. She knew that we were going to need an organization. Everybody else said, Peggy, there were 11 of us. What kind of organization do we need? And it's a long story. I won't go into it all here, but we said, okay, Peggy, we'll make an organization. And then we started doing our 501c3 applications, and we're naming ourselves. And we couldn't keep up fast enough with the growth of this model. We would call it Bay Area Collaborative Practice Group. And suddenly it was a California phenomenon, and then it was a US phenomenon, and then it was a Canadian phenomenon, and then it was an international phenomenon. That's what became IACP. Peggy and I became co-chairs, and then I became its first officially designated president. And you know the history from there. But the thing I think I'm proudest of is getting the Lawyer as Problem Solver Award from the American Bar Association in 2002. Stu and I shared it. That was their first such award, and that one meant a big deal to me because I never thought ABA and I would be on the same page, and we really are. They've been tremendously supportive of everything we've done in this movement. I was giving a training in Washington State. I did this a couple of times, and one of the Supreme Court justices of the state Supreme Court, Bobby Bridge, introduced me both times, and she gave a similar speech each time in which she talked about research that had been done in Washington State. It was done with people coming out of the court system after a full trial in a divorce proceeding. She said that the data showed that something like 80%, I may not have the exact number, but I'm in the right order of magnitude, something like 80% of the apparent winners in the litigation were seriously unhappy with process and outcome. And she observed that it would be fair to assume that 100% of the losers were pretty dissatisfied. So she said that that gives you an average about 90% coming out of court-based proceedings unhappy.